Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hope all of you are having a fantastic Labor Day weekend. Listen, we're going to circle back to one of our favorite states because we get to talk about them so frequently, and of course that is Illinois. And we're going to talk about an Illinois assault weapon ban, but it's not part of the Protect Illinois Communities Act or the piece of legislation that we have done way too many videos about, because some of you may not know this, but there was a couple of other jurisdictions that actually beat the state to the punch. One of them, of course, was the city of Naperville, and we've talked about Beavis v. Naperville already. The other one is Cook County in general, because as you know, Cook County, since they passed their assault weapon ban, has been an incredibly safe county. Well, it appears that that case is now at least trying to get to the United States Supreme Court. So we're going to talk about that because the petition for certiorari has been filed. We're going to geek out on that today. So today, let's spend a few minutes and let's talk about an Illinois assault weapon ban heads to the Supreme Court. Okay, America, and in particular Illinois, we're going to be talking about one of the many assault weapon bans. And for those of you around the country who don't realize this, number one, Illinois is an absolutely evil state when it comes to treating their lawful and responsible gun owners. Number two, even though we've spent a big chunk of time talking about the Protect Illinois Communities Act, there were other more localized jurisdictions such as the city of Naperville, and in this case, the case we're talking about today, Viramontes v. Cook County, that actually passed their own assault weapon bans. Now, I want you to understand the procedural history of this case as it now petitions to the United States Supreme Court for review. The case was heard before the Northern District of Illinois, where they ruled upholding, of course, the assault weapon ban on March 1st, 2024. And then the Seventh Circuit upheld it on June 2nd, 2025, which happens to be the same day that the United States Supreme Court denied review on Snope v. Brown. I'm sure just a coincidence. Okay, now, this case is not tied up with all of the other Illinois assault weapon ban cases. As you know, there are a whole big chunk of cases that have been consolidated that came out of the Southern District of Illinois. They are set for argument before a 3-judge panel of the Seventh Circuit on September 22nd of this year. We will obviously be covering that as it happens. Now, let's just get right to the heart of the matter here. Now, we can spend a lot of time geeking out and educating you on the case law, but you guys geek out here all the time so you know the case law. So we're going to hit some highlights of the petition to certiorari, which is a fancy way of asking for an invite to the United States Supreme Court. The issue presented here by the petitioners is whether the Second Amendment and the 14th Amendment guarantee the right to possess AR-15 platform and similar semi-automatic rifles. Now, even though the Seventh Circuit found that these particular platforms and firearms were more appropriate for military use, let us not forget that they actually found that the Second Amendment does not even address this platform of firearms. Okay, let me say that again, that the Second Amendment does not even cover these types of firearms at all, leading the petitioners here to point out the specific firearm at the center of this case, the AR-15 rifle, is unquestionably in common use. So there are no thorny factual questions on which this court's analysis will depend. The court should grant the petition. Now, as you know, there are many courts that will always point out that they believe the test is in common use for self-defense, and therefore it suddenly becomes the plaintiff's or petitioner's burden to establish that there are numerous instances of these firearms being used for self-defense. That is not actually the test. The test is in common use for any lawful purpose. And so the need really to develop a record about how many of these are, it's not that difficult. And it's the courts that just want to uphold these bans that actually overcomplicate the equation. The petitioners pointed out this way. In some, semi-automatic rifles, like the AR-15, are in common use for lawful purposes. Millions of Americans own tens of millions of them. They account for approximately 20% of all firearm sales in the past decade, and leading reasons for owning them include self-defense, target shooting, and hunting. Even though the Seventh Circuit has just clearly ignored case law and created new rules out of thin air to uphold these bans, I think the petitioners here were very kind because they put it this way. After this court repudiated the Court of Appeals interest balancing regime in Bruin, Courts like the Seventh Circuit here have expressed confusion and consternation at what exactly falls within the scope of bearable arms as a matter of plain text. The Seventh Circuit's reading of the amendment to exclude arms that the court judges can be dedicated exclusively to military use from the scope of the term arms at all is just one manifestation of the confusion. And again, I think that is a very polite and euphemistic way of saying this. I don't believe they're confused. I think they have absolutely positively bastardized the test to basically have a mutiny of Heller and Bruin. But this is a major problem, and the Seventh Circuit is not alone in creating this problem, leading the petitioners to point out the division here between circuits that have taken Bruin's guidance to mean there is an extensive first step arm or not arm inquiry, and those that have resolved the question with little difficulty based on Heller's work construing the term, betrays a fundamental misunderstanding of how to apply Bruin on behalf of the former. And again, this whole does the Second Amendment actually cover the activity, which has now turned into pages and pages and pages of analysis so that we can come up with things like in common use for self-defense or more appropriate for military use or any other creative new rule of law created out of thin air to uphold one of these bans, creates not only a constitutional crisis, but it begs the question, what exactly does the Second Amendment even cover at all? That this court in Bruin and Rahimi spent almost no time on the straightforward threshold textual issues posed by those cases is a strong indicator that the courts that have attempted to turn the textual analysis into a robust way to filter out Second Amendment cases without conducting a historical analysis have gone astray. But the continued confusion among the courts on that front indicates that they apparently need a clearer statement on this issue than the court has provided to date. Okay, now I want you to understand that, again, I do not believe that there is confusion at all, but what has happened, and this is by intent, is that when we're going to determine what's appropriate for self-defense, or in this case, what's more appropriate for military use, what we have done is we have injected balancing tests back into the equation, which Bruin theoretically stripped it from. And this is a problem that needs to be solved, and it needs to be solved right now. Why now? Well, as the petitioners put it, the issue raised by this case is exceptionally important. The AR-15 platform is the most popular rifle in the country, and modern semi-automatic rifles like the AR-15 are the second best-selling type of firearm in the country behind only semi-automatic handguns. If the Second Amendment does not protect the most popular rifles in the country, it is hard to see how it protects any firearms at all other than the handgun this court held protected in Heller. And that really does beg the question then that since Heller actually discussed handguns and a specific platform of firearm has never really truly been enunciated outside of Heller, so therefore we don't have clear precedent on other platforms, I guess it begs the question, if we allow this balancing test, courts to determine what's appropriate for military use, what's appropriate for self-defense, what does the Second Amendment protect? The petitioners also point out, instead, the Seventh Circuit's governing approach veers far astray from this court's precedents. In holding that the Second Amendment's plain text does not extend to all firearms, limiting the Second Amendment to a mere purposive declaration that the military's acquisition choices dictate the means by which civilians may engage in individual self-defense, rejecting the historical principle that arms in common use are protected and cannot be banned, and purporting to derive from history a novel military-like standard, the Seventh Circuit's reasoning is squarely at odds with the pronouncements of this court. And again, I appreciate the petitioners using kinder language, referring to it as confusion, but candidly, this is a constitutional mutiny. Now, this in common use test, which is a very simple equation, has been confused on purpose by courts that are hell-bent on upholding these bans. The petitioners would like the Supreme Court to bring all the courts back to the simplistic equation, which is stated as follows. History demonstrates that only arms that are both dangerous and unusual may be banned. And again, I want you to understand this, that when we're talking about outright bans of certain platforms of firearms, we do not need to engage in any type of historical analysis. Why is that? Because it's already been done for us. And the historical analysis says that the only historical traditions we have of banning particular platforms of firearms are those that are both dangerous and unusual. Taking dangerous out of the equation, which many firearms and all weapons theoretically could be, the question comes down to unusual. And I want you to understand that the Seventh Circuit Court of Appeals believes that the most popular long gun in America is not even protected by the Second Amendment. This ultimately leads the petitioners in this case to sum it up as demonstrated above. Further percolation in the lower courts is unlikely to do more than aggravate the confusion over how properly to apply this court's Second Amendment precedents to bans on types of arms, an important category of cases implicating not just laws restricting so-called assault weapons like this one, but also laws restricting other common firearms, electronic arms like stun guns, or firearm components such as ammunition magazines, and cause further muddying of the doctrinal waters in Second Amendment litigation more generally. Okay, petition has now been filed with the United States Supreme Court. We will carefully watch the case. The case, once again, is Viramontes v. Cook County. We're going to link the petition up down below so you can geek out on it for yourself. You don't have to take our word for it. Now, listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, that information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Why in the year 2024 should anybody even think about having self-defense protection? Because, 25 years ago, we would have never had this conversation. So what's different today?
Bill, we really saw a need a number of years ago when the volatility and divisiveness of our country started to change drastically. And we, by the way, are gun people protecting gun people. We come from a significant gun background.
Right to bear. That's right. Legal protection for self-protection. Listen, good lawyers aren't cheap. Cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.